Hello, everyone, and welcome to the panel that is organized by the research project called MARIS. It stands for Making Transparent the Invisible Surveillance. My name is Juraj Seifert, and I will be moderating this panel. I'm a doctoral researcher who is employed at this MATIS research project, and I'm a doctoral candidate at Vrije Universiteit Brussels and Université de Luxembourg. So our project is looking into whether we can actually count the use and usefulness of digital investigatory measures by and to law enforcement authorities in order to assess whether there are justified interferences with the right to data protection or not. Authorities that can help us develop this, our research, and measure this in a more objective and quantifiable approach are data protection supervisory authorities. And we therefore decided to, this year in CPDP, explore how do they supervise data protection compliance of law enforcement authorities. So our basic question today is whether the Law Enforcement Directive 2016-680 is being properly supervised and enforced or not. So this is not another GDPR panel. I will be quite strict with the timing of the speakers in order to allow enough time for Q&A in the end. Having said that, I have to say that we have a wonderful list of panelists today. We have the privilege actually to kick off our panel with our first speaker, Frank Schourmans, who is the member director of the Belgian Supervisory Body for Police Information, or Control Organ, or Organe de Contrôle. So Frank, Belgium chose to be the only EU member state to have a separate supervisory authority for police and the passenger information unit. So basically, you're the only DPA in Europe whose core business is the law enforcement or the national law transposing the law enforcement directive. All other member states have the same supervisor as the GDPR. So you are. It's a very peculiar case and also very interesting for our purposes. So could you tell us more about your work? What is it that you do? How do you do it? The floor is yours.
Okay, thank you. I'm having a little PowerPoint presentation. I'll try to remain within my 10 minutes. So I'll be going over it relatively fast. So something about our organization, our budget, then most importantly, a very swift overview of our enforcement activities, then a few concrete examples, and then I'll try to wrap up with some conclusions. As far as our organizational structure is concerned, Belgium is indeed a relatively peculiar case because we have three main data protection authorities. We've got the General Data Protection Authority, the Autorité de Protection des Données, APD. Then we have a specific DPA for intelligence services, and then we have the COC, the Supervisory Body for Police Information. You can see there what services lie within our competences. Mainly, of course, it is all the Belgian police forces, and we've got about 185 local police forces. And we've got one federal police, which in itself constitutes about 52 entities. It's relatively complex, but it has its advantages and it has disadvantages. I'll try to make clear what I think is important to have a specific DPA. So very swift, our organizational structure. We're a relatively small body, 11 full-time equivalents with a directorate of 3 members, 1 president and 2 directors. I'm one of them. Then we've got a small inspection service containing 2 higher police officers and 1 data protection expert. And then we got a secretariat with, at this time, 2, in fact 3 legal advisors, 1 IT expert and 1 secretary, a budget of 1.6 million euros. So it's relatively small, but when I compare it with the previous situation before the Law Enforcement Directive, when there was not a specific DPA, I think the the amount of personnel and the money that is being put into oversight on law enforcement is strong and rising. Overview of our enforcement activities. Here you can see the amount of it's a for the Belgium national police database. So you have to know that Belgium has one big national police database. A part of that, there are also specific and special databases, but there is one database that every police force has to feed, and these are figures of about 3 to 4 years ago about the amount of data. So it's one can see that immediately that the amount of data is huge, is enormous, and it's a challenge, of course, for us to try to keep up with those figures. But it gives you an idea of what we have to do. Our enforcement activities, we have some reactive enforcement activities and proactive enforcement activities. The reactive enforcement activities are handling the right of access rectification and deletion requests. We are probably, I think, the only, I'm not sure, but I think we are the only country that decided to keep only a system of indirect access. So there is no direct access for the police force. We are handling all the indirect access requests, and we have to treat them. The big advantage when we compare with the previous situation is, for example, that we have access to the main police databases. Not all of them, that is all the time to have access to all the police databases, but the main police databases, the general database, we have access to. You can see there the number of requests. We had a steep rise when the law enforcement directive and the transposition Belgian law was in practice. Then in 20 we had a little drop. At this time, for example, in January, we are at about 50 files just for the month of January 2001. Next to those files that are very important, because files of indirect access gives us the opportunity to go into certain problems, and it gives us the opportunity to discover certain problems and do investigations. We also have opinions, evidently, on legislative proposals. That is a priority for the supervisory body, because it means that we have a direct impact on legislation. We have to do our opinion within 60 days, sometimes 15 days if it's urgent. Next to those opinions that are demanded by the legislative branch, we also make ex officio opinions. For example, I cite here two important ones: the use of camera surveillance in the workspace of police forces, and the filming of police activity by the public. This is, as you well know, a very important problem. The fact that civilians more and more start filming every police intervention, and it raises a lot of questions, legal questions and other questions. We're trying to make a general recommendation on how to handle those situations. We also do complaints about unlawful processing by police members. We were not able to handle all of them, so what do we do with those complaints? We either, when we feel that it's a minor issue, we send it to internal affairs of the police force itself. Sometimes, when you think it's a serious breach, we can send it to the public prosecutor's office. We always demand to draw up a police report, and so that the public prosecutor has the possibility to express his view on the need to prosecute or not to prosecute. But we limit ourselves to the unlawful processing, because a lot of complaints are about unlawful processing, but also about other violations like professional secrecy, slander, unjust treatment, etc., etc. Those are things that we do not do as data protection officers. There are other oversight bodies in Belgium to handle those complaints. We have, very importantly, our proactive, most important proactive activity are on-site visits, which is in fact the core business of a supervisory body, and stands in relation with different legal obligations that you all very well know, like making data protection impact assessment, doing the notifications when there's data breach, etc., etc. What themes do we treat? Well, different themes. There is a global assessment of the police force insofar as they're respectful for global data protection rules. Then the way that they feed the national police database is something that we also go into, and what's the quality of the data, the fact that they respect data retention periods, which is it's a huge problem in Belgium. The application of secret camera surveillance, ANPR, evidently. The constitution of ad hoc databases, as I've said, apart from the general databases, every police force can also have specific databases on specific issues, specific phenomena, and that is also a big issue. And we see that there's a proliferation on databases. So the on-site visits, proactive. Here I give some examples. I will not go into them because I can see that my time is going very, very rapidly. We on those, as a result of those on-site visits, we do give recommendations, but we also use our corrective measures, our corrective powers. We can give a warning, we can impose a time period to comply with our recommendations, we can have a partial or a complete shutdown of data processing, we can refer the file to the public prosecutor's office, etc. So I think that we have really the means, and we do use them when it's necessary to go on with corrective measures. Those are the numbers. I'll go over them now because of time constraints. Some examples, important, 2 examples. One that is, I'll go over the recommendations, but I'll go directly to the corrective measures. So we make an analysis, for example, of the existing special databases. We oblige them to make the necessary records for those processing activities. We oblige them via IT means, for example, to fill in a reason every time a police officer does consults a police database, which is a huge problem at this time. It's very difficult to know when why a police officer has done certain processing operations, etc., etc. We've had two main dossiers that we have was the facial recognition ban last year in 2019 on the Brussels airport camera use, and a very recent one is the use of drones by a local police force in light of the COVID pandemic. There were a lot of problems. Things were not okay. So we put in a time constraint. Within 4 months, they have to make sure that they abide by Belgian law, and we have limited the use of the drones in 2 cases. Real crowd control. That means that the drone is flying about 70, 100 meters above ground surface, and they can use a drone if there is an order of a prosecutor or an investigative judge. Those are 2, I think, important examples. Some conclusions. I think it's important, and I believe that Belgium is the example. It's important to have a specific police dedicated DPA if you want really to have a clear oversight of police activity. I've read a recent report on the Dutch DPA, for example, and one of the criticisms was that the general DPA does simply not have the time to invest in in police activity, which is, I think, a huge advantage of having a specific police dedicated data protection authority. There remains a difficult relationship within the judiciary, as when data are also from part for ongoing judicial investigation, and then the mixture between competences of prosecutors and judges and our competence, it gives sometimes legal issues. So the coexistence between data protection law and penal procedure law remains a difficult issue. I think we have enough corrective powers. We do not have, that's the only thing we do not have. We cannot give an administrative penalty. That was a deliberate choice of the Belgian legislator, and that is something that that could be debated about. We are not asking to have that. I think we have enough corrective measures to make our job possible and worthwhile. So I'll keep it here, Juraj, because I know that we have a time frame. Thank you.
Thank you very much, Frank. That was an excellent presentation. And there are already some questions for you, not only from me, but also from the audience. But I will keep them for later. We will now move to our second speaker. So our second speaker is, well, first of all, I'm very grateful that you are with us, because it was really on the last minute. Our second speaker is Electerius Keliodakis. He's a lawyer admitted to practice in Greece and co-founder of the Greek civil society organization Homo Digitalis. And you are also an observer member of the EDRI network. Now, your organization is quite also peculiar, like Frank's is, but from another point of view, your organization is one of the rare NGOs that actually has some experience with LED, and we're trying to enforce national laws transposing the LED. Most of your work was done in Greece, but I know a little bit about your work, and I know also a little bit about how the directive is being supervised and enforced in member states. So I think the example and what you've been through and what you have learned is something that is not only a Greek case study, but would happen in many other member states. So the floor is yours. Tell us, how did it work for you?
Greetings to all from Athens, Greece. Many thanks, Juraj, for the invitation today. It is indeed a great pleasure to be here with you representing Homo Digitalis, and I will start with my presentation right away. Here is an overview of my intervention today. In the first part, I will briefly describe what are the characteristics of a strong supervisory authority, while I will also reflect on why this is important for both civil society actors like Homo Digitalis and individuals. Next, in the second part, I will offer some positive and some negative examples from essays, practices, or lack of practices in the law enforcement sector over the last 2 years. And finally, in the last and third part, I will just think out loud and share with the panel and the audience some doubts or questions that I have. So let's begin. In this slide, I'm trying to depict in a funny way the characteristics of a strong and of a weak supervisory authority based on the Articles 41 et sec of the Law Enforcement Directive. So on the left side, we have essays and the way that the essays should be in the modern law enforcement directive era. These essays act with complete independence. They are provided with the necessary human, technical, and financial resources. They proactively, this is important, monitor and enforce the application of the law. They promote, of course, public awareness. They dynamically exercise their investigative, corrective, and advisory powers. And of course, they bring infringements of the law enforcement directive to the courts, and also they engage in the legal proceedings. On the contrary, the right side of this slide describes the version of the supervisory authorities before the law enforcement directive that should now belong only to the past. There we see supervisory authorities that lack of effective independence. They have limited sources. They are hesitant to exercise their powers. They do not educate individuals on their rights or controllers, law enforcement authorities, about their obligations. They do not impose effective, proportionate, and dissuasive penalties. And of course, they do not publish activity reports. In the next slide, I will briefly speak about why do we care? Why it is important for supervisory authorities to be strong? I think that we all know why. First, effective enforcement of the Law Enforcement Directive relies on strong data protection actors. This means that potential violations can be intrinsically hidden, which can jeopardize the enforcement of the lead. Also, the use of smart tech in policing and modern management activities creates important challenges for our rights and freedoms. So under these circumstances, the active role of SAs in protecting individuals' fundamental rights is crucial. Second, in most member states, civil society organizations cannot lodge complaints without an explicit mandate from a data subject. However, data subjects, as you know, may not even know that their personal data has been processed, while in case they know, they are not always willing to come forward and mandate the civil society organization to act. This is why it is very important for a supervisory authority to independently, proactively exercise its investigative and corrective powers. Thirdly, um, a strong supervisory authority creates trust in the eyes of the public. It underlines that the rule of law, democracy, and fundamental rights are not just negotiable principles and values, but instead they form the foundation upon which the EU and the EU sovereign member states are built. But in order to keep our trust and faith high, we need to see more results. We need to see more actions. We need to see more penalties. In the next slide of mine, I will have now reached the second part of the presentation, and I will first give some positive examples of supervisory authorities' actions because I'm a positive person, so I will start by the positive things. The first example is the United Kingdom. There, the commissioner, following the actions of the civil society organizations Liberty and Privacy International, investigated the trials of live facial recognition technology in public spaces by the South Wales Police and the Metropolitan Police Service. Also, the commissioner issued an opinion on this matter, whilst he intervened in the related court case of Liberty and Mrs. Bridges in order to assist the court. Liberty and Mrs. Bridges won the case, and live facial recognition in public spaces was declared unlawful by the UK Court of Appeal. In another example, Italy, following again the actions and reports of another civil society organization named Hermes, the Italian DPA stopped the trial use of a facial recognition system in the city of Como, which was pushed by private corporations like Huawei. It is important again to remember that based on Article 47 of the Law Enforcement Directive, and that also the Belgian DPA stated in its own presentation, the supervisory authorities have the power to impose temporary or definite limitations on data processing activities, including a ban. Nevertheless, in other cities of Italy, the installation of similar facial recognition technologies is already announced, such as Turin and Udine, and Hermes is trying to fight back. You can stay informed about all these related actions by following the Reclaim Your Face campaign of the European Digital Rights EDRI network. Of course, you said, Ray, that I'm from Greece, and I have plenty of examples to offer from the Greek state. So, following Homo Digitalis request, the Hellenic Data Protection Authority issued an opinion in January 2020 regarding the Greek Data Protection Act implementing the Law Enforcement Directive. The DPA underlined in this opinion the important shortcomings of the law, and this was quite useful for us because, we have already initiated a complaint against the Hellenic Data Protection Act before the European Commission, so we were able to inform our complaint based on the DPA's findings and build a stronger case. Second, again, following Homo Digitalis' request, the Hellenic DPA started investigating a smart policing contract of 4 million euros between the Hellenic police and the private vendor called Indracom Telecom. This contract is related to the development and delivery of smart devices enabling facial recognition and automated fingerprint identification during police stops. The investigation is still ongoing, but based on an article published just yesterday by Reporters United and Algorithm Watch, the Hellenic police is confident that they will manage to acquire 1,000 of such devices before summer 2021. So it appears that despite the DPA's investigation, the Hellenic police doesn't seem to be at all worried. Third, again, following the 2 strategic complaints filed by Homo Digitalis before the Hellenic DPA, the DPA started investigating a central biometric database of the Hellenic police that includes fingerprints and facial images of all the Greek passport holders. And again, you can stay informed about all these actions by following the Reclaim Your Face campaign. In the next slide, I try a little bit to reflect on the negative aspects that exist, because there are a lot. So if we ask ourselves, are these actions that I just mentioned enough? I think that the clear and the honest answer is no. As you probably have noticed, supervisory authorities are mostly responding on unlawful data processing activities by law enforcement authorities, and they are following civil society actions. They are not proactively monitoring and enforcing the application of the lead. However, we think that supervisory authorities need to be in the driving seat when it comes to investigations and monitoring. Moreover, supervisory authorities should publish more decisions and guidance on lead issues. Finally, differences in law enforcement direct transposition at member states level create a dissimilar level of protection of people's rights and could hamper data exchange between law enforcement authorities. And in the next slide, I would like also to share with you some important findings and recommendations from a forthcoming publication drafted by a number of skillful researchers at KU and CTIP, namely Plixavra Voyagoglu, Catherine Tavares, Stefano Fandin, and Pierre DeWitt. This is a forthcoming publication of them. The paper is focusing on the right to access under the lead and the PNR Directive, another challenging piece of legislation. It covers 11 European countries. I'm sorry, can we go back to the previous slide? I did a mistake. It covers 11 European countries. Individuals highlighted the lack or incompleteness of proper transparency measures when trying to exercise the right of access before law enforcement authorities. Also, they experienced significant disparities in the handling of their requests. And some of the key recommendations of the authors is that stronger oversight of the implementation of the directive from national supervisory authorities and EU stakeholders is necessary in order to remedy the identified gaps and fallacies. Finally, in the very last slide of mine, I would like just to, again, think out loud and pose some of my doubts and questions. How are we able to boost supervisory authorities' efficiency and engagement? Do we need more funds? Do we need to follow the Belgian example, which seems to be quite successful? Do we need within a supervisory authority to have a dedicated department only to deal with law enforcement directive issues? Also, it is important maybe to create a channel of cooperation between civil society organizations and data protection authorities. We see that they work already well together, so there is a lot of future there. And finally, is there the chance to have an EU-wide guidance? Can, for example, the EDPD deal with the law enforcement directive issues, having in mind that already they have a heavy workload on GDPR? I am done, and many thanks for your attention.
Thank you very much, Electerius. That was excellent. Now we heard how things work on the ground in one member state, in another member state, and in some other third member states as well. So we can move from the national perspective to the European perspective. Our next two speakers come from the core of Brussels EU institutions that work in the area of data protection and law enforcement. Our next speaker is Fanny Couder. Fanny, you are the head of sector for the supervision in the area of freedom, security, and justice at the European Data Protection Supervisor. And you joined that EDPS Supervision and Enforcement Unit back in 2007 when the EDPS actually started acting as the sole and the main supervisor for the first EU law enforcement agency, Europol. So the first EU law enforcement agency to be supervised by the EDPS. So can you share with us some of your experiences, in particular with Europol, And I don't know if you can comment on this, but I was wondering whether you could also tell us about the lack of activity of your office neighbors, the European Data Protection Board, in the area of LED. Recently, my colleague from VOB Gloria, Gonzalez Fuster, published a report for the European Parliament where she basically demonstrated that the EDPB work between 25th of May 2018 and nowadays related to LED amounts to an empty page on their website. So yeah, I don't know if you have any thoughts on that, but in any case, the floor is yours.
Thank you, Juraj. Thank you for putting together this very interesting panel. Sorry, and thank you for allowing me to express my views on the topic and participating to the debate. I won't comment on the activity of the EDPB. I think, well, they have been very active. Actually, we are quite a lot in touch with the Europol Cooperation Board, which is not part of the EDP, but a specific forum for national authorities supervising in relation to the supervision of Europol. And there we had quite active discussions with them that I would like to point. And I know the BTLE is a section of the EDPB focusing on law enforcement is also quite active, maybe not as publishing as much as the other EDPB subgroup. But to come back to my presentation, maybe, so I would like to try to tackle, well, first to give my opinion on the question you're asking to the panel. Is effective supervision a myth of a reality, and what are the conditions for success from the point of view of the DPS? And maybe say a few words on the role of data protection authorities in the protection of fundamental rights in the context of digital investigation methods. So with regard to the question you asked to the panel, first I'd like to highlight so as you say, the EDPS Supervisory Authority of Europol since May 2017, of Eurojust since December 2019, and this year will become the supervisor of EPPO as soon as they start their activities. So one big difference, I would say, with the national supervisory authorities of police and the justice sector is actually the number of authorities we have to supervise. I think Frank referred to 100 or more than 100 authorities that they have to supervise. Even if it's true that the authority we are in charge have a huge volume of processing of personal data with a high impact on individuals. Think only of Europol active on the fight against serious organized crime and counterterrorism. So this reality has an impact, I think, on the way how we approach supervision. And yesterday, actually, I listened to the panel on oversight and enforcement, and I felt I had, well, I agree quite a lot with the conclusion of the representative of ARCEP, the French regulator of telecommunication, on a view on the supervision. One thing she stressed actually that because their goal is to move from a monopoly situation to a free market in the sector of telecommunication, the focus of their supervision is put on dominant actors. And this allowed them to be much more focused in their supervision, and maybe more importantly, to develop very close relationships with the entity supervised, allowing to identify problems before they appear to and to react quickly. And she also referred to a lot to all these gray areas that they were able to, or where problem arise, they were able to solve because of this relationship. So I say that I'd like also to define what is efficient supervision. What is effective for me? For me, it doesn't mean comprehensive. Because if not, I think this is indeed an impossible task. I mean, none of the supervisory authority will have sufficient resources. So effective supervision for me will mean supervision with impact, which is focused, thorough, which can rely on a solid cooperation framework with the agency being supervised, and in particular with the DPO. The role of DPO is key. The goal of the supervision, the law enforcement, well, is to increase transparency of data processing activities in an area which is quite opaque and ensure compliance. So ultimately, this is to contribute to creating a culture of data protection within the authorities being supervised. So from that perspective, one key element of supervision is a dialogue, I think, inherent to the activity of supervision between the DPA and the law enforcement authority. We call a law enforcement authority to explain and justify their activities, but we look at it from a different perspective. We propose a different reading, and ideally there is an exchange of view, a discussion with the goal of arriving to a common understanding, to an agreement of the way how to implement the legal safeguards. In case we don't get to this agreement, then we use our corrective powers, and the law enforcement authority is given the possibility to challenge this decision before the court. But in order to achieve this goal, what do we need? So obviously we need resources, because in order to have, to build a constructive dialogue with these authorities, we need resources. But we also need a strong DPO. I think that's a very key element in order to ensure a constructive dialogue, because the DPO is an independent advisor to the authority with expert knowledge in data protection, but he knows very well the core activity in the business of the agency better than the DPA, and he can act as the interface. And we could see that, so we have been, for instance, just for Europol, we're in constant contact with the DPO of Europol. We have regular meetings. Just for 2020, we had 8 of these meetings in addition to all bilateral communication on specific case. So this means a lot of time and investment on both sides. But we could see that many of the success stories, I would say, were thanks to efficient communication between both sides, where the DPO were playing a key role. And the other thing you need is actually adequate and sufficient tools, meaning powers. So by that, I mean not only corrective powers, but also investigative and advisory powers. So just to tell you, in 3 years of supervision of Europol at the DPS, we only had 2 cases that ended up with a need to exercise our corrective powers. So we issued a ban in a case where we found that Europol did not have sufficient legal basis for the processing operation of state, and we issued an admonishment in relation to the processing of large data set. But my point is that most of the supervisory work is actually advisory and investigative work, and in most cases does not end up with the use of corrective powers, which should be seen in a positive way. That being said, so does it mean that, as we know, DPAs have less powers, in particular corrective powers, in the field of law enforcement than in the GDPR? The same happened at EU level. The DPS has less powers for the supervision of European institutions than for GHA agencies. So to give a concrete example, for instance, for Europol, we don't have the power to order Europol to bring processing operation into compliance with the Europol regulation. We don't have the power to impose them a temporary or definitive limitation on the processing. We only have the power to ban, which is much more impactful as a measure. We don't have the power to issue administrative fines or to order suspension of data flows. And for Eurojust and EPO, we don't even have the power to impose a ban or even to refer a matter to Eurojust or to the Parliament, the Council, or the Commission. So do we need these extended powers? Is it justified to have less powers or to justify supervise GHA agency? I just say we used corrective powers only twice in 3 years. Well, I will answer clearly. I think, yes, we need them. I know it's not justified to have a reduced amount of powers in a field where processing of personal data has such a high impact on the individual. But beyond that, I think that having the full range of powers that we have in supervising all the European agencies would allow us to have more granularity in the exercise of our powers. And yesterday, the representative of ARCEP was advocating to empower supervisory authorities with intermediate tools in order to be able to act quickly, and tools with a lower political cost. So for me, these intermediate powers are precisely the type of powers DPAs are deprived of in the context of law enforcement. So to take the example of the DPS, if we have to use our corrective powers, we have to basically choose between issuing a warning of an admonition, which are meant to signal data processing activities that are not in line with the applicable framework, and to invite, and with this, we're inviting the agency to adjust its practices, or to issue a ban. So we go from one extreme to another, which might be justifying sometimes, but in many cases, being able to issue an order or a temporary limitation could be much more effective tool. And this intermediate power are key to ensure balanced supervision. So I think that I run out of time. Maybe I will just briefly touch on the second question about the role of supervisory authorities in the context of digital investigatory measures. So I'm thinking about processing of large data sets, for instance, and the need to use machine learning or AI in order to make sense of these data sets. We know that this is one of the issues that is being dealt by the European legislator in the context of a recast of the Europol regulation. And here I would like to stress that I think that the role of supervisory authorities to enforce the legislation, not so much to devise which safeguards. We are here to verify that controllers have implemented adequate technical and organizational safeguards, to provide evidence that there are gaps maybe between legislation and practice. But I really think that the legislator should keep this role of defining the safeguard for one simple reason, which is that when the legislator defines this safeguard, this allows for a democratic debate that will not take place if the safeguards are defined by supervisory authority or the controller. So it doesn't mean that the legislator has to regulate everything, because if not, then the data controller does not have sufficient flexibility to perform their activity. But aspects that should be subject to democratic debate should be regulated by the legislator. Thank you.
All right. Well, thank you, Fanny, very much for your intervention. We now learned how things look from the point of view of EDPS, and this is a nice introduction for our final panelist, who is Anna Moschibroda. Anna, you spent the last 6.5 years working for the Data Protection Unit in DG Justice of the European Commission. You're focusing mostly on data protection for law enforcement. And so I was wondering, what is your helicopter view on this matter? Because I'm sure you are in the position to have the best overview of how the LED is functioning in the 27 member states. And yeah, so how are the DPAs doing their job when it comes to LED supervision and enforcement according to you? The floor is yours.
Thank you very much, and good afternoon to everybody. Thank you also for organizing that panel. I think it's a very important topic and not so much discussed, so I think it's a great idea to take this space today to talk about those issues. So indeed, how I thought I could contribute to this panel is to basically give you, try to give you a general picture how the member states have actually transposed a law enforcement directive led as regards the provisions relating to supervision. So as you know, that the LED is now, in terms of completeness, transposed in majority of the member states. There are only 3 member states against which the infringement procedure are still ongoing for lack of transposition or incomplete transposition. But now the focus changes into actually looking into how that transposition is done. So is it correct? Are there any conformity issues? So discussions are still ongoing with the member states, but I think the general flavor indeed I can try to give you. So as a very general comment, what I can say is that majority of the member states provided comprehensive rules concerning the protection of personal data. And when looking at the particular provisions, so the national rules largely reflect the main principle behind those provisions. So they give the core of what is required under the LED. Although quite often we can also see that the specific requirements are only partially covered or are entirely missing. And there is no any specific trend among the member states. So going into more concrete and specific provisions relating to supervision, I think the most important and the most interesting for us today is just to look how the member states have transposed Article 47 of the LED, which is about the powers of data protection authorities. So as it was mentioned today, we see the difference between the LED and the GDPR. So while the GDPR is quite specific, and essentially it bullets the powers, investigatory powers or coercive powers, the LED is much more general. So it prescribes the general goal, which is to grant effective investigatory powers or effective coercive powers. But unlike GDPR, it does not bullet them down. However, it puts down certain minimum. So in terms of investigatory powers, that minimum is that it has to, the DPAs have to have access to data and to information necessary to exercise their tasks, or to give examples of powers, and that is in the context of coercive powers. So I think that certain reflection is already warranted on that basis, which is that it is indeed for the national law to really give the meaning into the powers that they give to the data protection authorities, so to speak, to put the meat on the bones. But again, of course, I wanted to stress that the LED requires the powers to be effective. So they have to give necessary means to data protection authority to perform their task. So, and the other reflection, I think, is that merely a literal transposition of that specific provisions of the LED, well, it is not necessarily the best approach. Maybe let's take a look, at the specific powers right now. So in terms of investigatory powers, what we see that it's basically all member states provide for investigatory powers, pretty much in line with what is required and how it is worded in the law enforcement directive. So there is a general capture giving the investigatory powers, and the minimum powers of access to data information is provided. Then, on the positive side, what we can see is that very many member states indeed further specify the powers to provide for additional powers. So, for instance, there are specific provisions regarding the powers to conduct investigations, to do audits, to enter premises, to access the data on the specific processing mediums, to make copies of the data, and so on and so forth. I think this is indeed the very positive trend among the member states, and that is exactly the example of trying to put the meat on the bone in terms of investigatory powers. We also see that in the number of member states, the investigatory powers seem to be aligned with those which the DPAs exercise under GDPR. And here again, I will just come back to the observation already made before, that basically, except Belgium, the authority is the same for the GDPR and for the LED. And we also see in some member states that this alignment with the GDPR investigatory power is also done by basically direct cross-reference to the powers granted under the GDPR. So if there is a group of member states that do so, but it's not the rule. It's not the rule for all member states. So now going to coercive powers. So the vast majority of the member states provide for the coercive powers pursuant to the those listed under the LED. In that number, quite a number of the member states have literally transposed the requirement of the LED in terms of the coercive powers. And what we also see that the references to GDPR seems to be much less frequent. So to give you a bit of a context, because I think now we're getting a bit on a technical discussion, so just as a kind of a reminder, the LED basically indicates three coercive powers, which is to issue warnings, to order, to bring processing into compliance, and finally to ban the processing. So what we see is that most of the member states transpose those coercive powers as stipulated in the lead. Nevertheless, there are member states who fall short on some of those powers. So out of the three that I've mentioned, they either provide for only one, which is, for instance, the power to issue warnings, or only the powers to ban the processing, but they do not provide for the other two, or they provide the two, but one of those is missing. And again, there is not a clear trend between how the member states are doing so. In some cases, what we are also noticed that in some member states, while the powers are there, member states are limited in exercising the full array of their coercive powers under their laws when they are acting under on certain specific contexts. For instance, under the in reply to the complaints from the individuals. So in those cases, data protection authority seems to be able to seem not to be able, for instance, to issue the ban on processing. I think what is also an interesting observation is that in very many member states, member states have provided, they included provisions relating to fines. So while the provision relating to fines is the part of the transposition of law enforcement directive, and also in some member states, the power to issue fines is limited in some way or the other. So in some member states can only issue fines to natural persons or private entities, which, I mean, as we are in the context of basically supervision of the public institutions, that would basically mean that it is only possible to issue fines against the natural persons or the processors if they are private parties. I will move on and just now tackle the advisory powers. So again, what we see is that in most member states, they indeed provide the transposition of the advisory powers, and limited number of member states, there are some differences comparing with the requirements of the directive. So for instance, the member states DPAs are cannot issue or not, they are not granted power to issue opinions on their own initiative, or there seem to be no power to issue opinions to the public institutions, which is, of course, in that context of law enforcement, an important point to note. Finally, we also have the powers of bringing the infringements to the attention of judicial authority or to commence the proceedings. And again, most of the member states provided for that possibility. However, there are some member states where this provision has not been transposed. So what I can say, maybe just to conclude, is that, as I said, it is for the national law to put the meat on the bones in terms of the powers of the DPAs as against law enforcement authorities. But it is also possibly for the DPAs to basically claim their space and act assertively in terms of implementation and interpretation of the powers that they are being given. And in this context, I only wanted to mention that the Borders, Traverse and Law Enforcement subgroup, so EDPB, is now is working on the guidance on the powers of supervisory authority. I will stop here, and I will be willing to reply to questions or provide more information if the time allows. Thank you.
Thank you very much, Anna, and thanks to all the speakers for keeping the time, because now we have 18 minutes left for the discussion and the questions from the audience, which we already received a lot. I'd just like to comment on what, Anna, what you said about the BTLE subgroup working on the guidelines on the Article 47. They're working on those guidelines since a couple of years already. So I think that this is taking a bit too long. And also what you said about how Article 47 was transposed in member states, I think it is a very and the fact that not all three corrective powers that are listed there exist in all member states is also a consequence of the weakness of that article, because it doesn't oblige member states to have even those three corrective powers that it mentions. It just says these are the corrective powers that DPAs should have by way of example, and therefore, such as there are a lot of qualifiers there that make it quite a weak provision. So I think that's part of the problem as well. But I will start with the questions for Frank, because Frank, you have received a lot of questions from the audience, and
Yes, I saw that.
also an opportunity for you to, of course, comment on any other thing that the panelists have mentioned that you would wish. So there was a question about the indirect access that you have in Belgium. That is, in my opinion, but that's more a question for the legislator than for you. Why do you have this system? In my opinion, that's an incorrect transposition of the directive. So I don't know whether you can comment on that and what the Commission will do. We should ask Anna about this. But there is also a question of what do you disclose to the data subject in that context. And then there was a question about elaborate on clashes between the criminal procedure law and the data protection law, about what do you mean when citizens are filming the police? Is that your competence? Is it processing under lead? And then there was a question about what kind of administrative measures you are lacking, but I think the audience misunderstood. You have corrective powers. You just wanted to say you don't have administrative fines.
Right.
You have other corrective powers. So right. Now the floor is yours for answering all those questions.
Okay, thanks. So first question about the what do we answer to the data subject? We answer that the necessary investigations and checks have been made, which is sometimes frustrating for the data subject and for us. There is a provision in the Belgian law that a royal decree can be taken to determine what sort of information could be given en surplus, donc which other information that could be given, but up till now, though the provision is, it's about 2 years now that we have a new Belgian data protection law. Until now, that decree has not been taken, so we are obliged by law to limit ourselves to that phrase that the necessary investigations and checks have been made, which gives a lot of problems. I hope that with our new government, and we have already asked the government to make sure that we are in the possibility on certain cases to say a bit more. And there's even when the retention period of data are expired and the data have been erased, I'm not allowed to say that to the data subject, which is problematic. Why did Belgium choose for indirect access? Well, it's a political choice. It was, I think, foremost police pressure. So the Belgian police does not want to have that direct access. They're very pleased that we do the job for them. Is it a correct transposition of the lead? It's a big issue. I personally think it's a problematic. But when you read the Belgian law and the commentaries, they try to give arguments why that system is correct. And I think it's indeed for the European Commission to see if that transposition is okay. On the relationship between data protection law and penal procedure law, I could talk about several hours. I don't have the time. But one of the problems that we face on a daily basis is that, for example, in indirect access files, we do not know beforehand if the information isn't still in an ongoing investigation, or if the information retains to a file that is already closed, which is very important, of course. And so the Belgian data protection law says that the rights of the data subject, when we're talking about an ongoing investigation, have to be exercised in accordance with the penal procedure law and not the data protection law. So, which poses a lot of problems. So I don't really have the time to elaborate, but it gives us time to time a lot of issues, and the most important issue is that we do not know beforehand if the information is still an ongoing investigation or not. The filming of police operations by citizens, it's of course the competence of the supervisory body. It's also a demand from the police forces themselves. At this time, a lot of police forces do really have trouble knowing what can they do when civilians are filming their operations. So they ask us, can we seize a smartphone? Can we seize can we seize the smartphone? Is that legal? Is that not legal? The Belgian law is very silent on the whole matter. So it's not very clear what they can do, what they cannot do. Police officers also have their right on data protection, and there is an important judgment of the European Court of Justice, which ascertains that also police officers have a right to data protection. So it's a very difficult balance, and it's certainly on demand of the police forces that we will try to issue an ex officio opinion on what the boundaries are when it is certainly not possible to seize a smartphone, for example, or on other cases when it could be possible. But it's a very, very difficult exercise. What if the police force does not abide with our corrective measures? First of all, I have to say that until now, and we have issued in practically every on-site visit corrective measures, it has not happened. And so police until now do abide with our corrective measures. If they do not, what we can do is file a report and send that to the prosecutor's office. The fact that a police force would not abide with our corrective measure is a criminal offense, and of course it's very clear that a chief of police does not want to have doesn't want to be the actor of a criminal offense. But until now, we did not have to go as far as that. I think that on the questions, that wraps up the answers to the questions. What I would like to say when I hear about the supervisory role of DDPS and Europol, it's very difficult to compare Europol with national police services. The amount of awareness and expertise that is within Europol on data protection is by far not comparable with local police forces in Belgium. For example, we have police forces containing 50 police officers, very small forces, and we have the one in Antwerp, which is more than 2,000 officers. There's a big difference between those police forces and the way they handle data protection issues. What I do want to say is that after 2 years of having a dedicated police DPA, that the awareness within the Belgian police on data protection issues, on data protection obligations, is extremely mounting and rising, and really it's no comparison within the situation as it is now when it was a few years ago. So I think we're really making progress. Thank you.
Thank you very much, Frank, and I hope that is also a soft effect of the fact that the law enforcement directive was adopted and was transposed in Belgium, which is also quite important and should not be neglected. I will move now to Electerius. There was a question for you about how can you effectively exercise your right as a data subject if you don't actually know what is happening with your data. So I think the question is, what if you don't have information, how can you then effectively exercise the right of access and all the other rights that follow after having the right information? For example, the audience mentioned this allegedly a secretive contract between the Greek police and Palantir.
Thank you, Uri, for your question. Indeed, it is very important to be informed about what is happening. We saw that in practice at Homo Digitalis in Greece, because, for example, when we had the new law enforced in the end of August 2019, 3, 4, 5 months passed, and we didn't see any information on the Hellenic Police website about, for example, the data protection officer of the Hellenic Police, or what are the data subject rights that and how we can exercise our rights, to whom we should say, for example, send, for example, an email asking about what data the Hellenic Police has on our side. We spend 2 or 3 months sending emails to the Hellenic Police asking how we can exercise their rights. We didn't get any replies. We informed the DPA about this matter, and magically, a few weeks later, the information on the Hellenic Police website were available. What I'm trying to say here is that it is very important for individuals to be active. It is very important to ask questions. If you don't know what your rights are, of course, the Hellenic Data Protection Authority should have informed the data subjects in its website. But if you don't know what your data subjects' rights are, you should be able to ask the controller, in this place, the Hellenic Data Protection Authority. As regards the contract between Palantir and the Hellenic State, this was in a different setting because it was related to the COVID-19 monitoring situation. It was indeed a secret one, but it is outside of the scope of this panel. We have also taken actions in this regard, and we are waiting for the DPA to issue an official announcement on the topic because they are investigating the matter.
All right. Thank you very much, Electerius. And now I will move to Fanny. I was wondering whether you could share with us a little bit, and I think Frank underlined correctly the enormous difference between supervising Europol and supervising national police forces. So could you tell us how does it work in practice when you see that Europol is doing something that you think that is not in line with their data protection framework? How do they react to this? Is it a difficult dialogue? Do you have to reach out for your corrective measures immediately? Or if you just share a few anecdotes about the practical experience.
Well, I think the way how we react in those cases is very similar to what Frank has described as in our slide, because we just exercise our power. So the fact that we have a very close relationship with the DPO. Normally, we start at the level of the DPO asking question, and then depending on what happens, we go on, because I understand your question is when we discover something, so we start an investigation. That's so as any DPA would do an investigation, and I must say that normally, thanks to this close relationship, they are quite reactive. We can also go on site and make verification we need to do. We talk to the DPO, we talk also to the operational staff where necessary, we collect evidence, and then we come to a conclusion. So it doesn't, if we can come to an agreement with Europol, meaning we agree on which should be the corrective measure to implement, there's no need to use our corrective powers. When this is not the case, then we have to use our corrective powers and take a decision. I don't know if this answers your question.
Yeah, so did you use corrective powers against Europol in the last?
Yes.
You did?
Twice.
Okay.
Twice. So we, as I say, we issued a ban with regard to the fact that Europol was hosting the FIU network, we thought they didn't have the sufficient legal basis under the Europol regulation. And we, in September, we issued an admonishment over their processing of large data sets. So this is an ongoing file, so we're in discussion with them. Yeah.
Okay. So this large data sets, this is still ongoing?
Yes.
Okay. All right. Well, then I'll move to Anna. We still have 2 minutes left, so I have a very short question for you. Is the Belgian transposition of the right of access incorrect, or is it the incorrect transposition of the law enforcement directive, in particular Article 17, and are you going to start infringements against Belgium?
What I can reply to this is that indeed Article 17 basically says that it is obligation of the data controller to reply to the request of the data subject. On the infringement action, well, as you know, we are doing all this transposition check. Right now, we are looking into whether member states have correctly transposed the provisions of the LED. Yes, I think that there's a good assumptions that the infringement actions will follow. It is maybe not the best place here and now to say against whom and when and to give you more details of those actions. But in this place, I can only say that the current Commission is indeed focused on enforcement. So that would be an important part of my work looking forward.
All right. Well, it's 12:59, which means that now we have to wrap it up. I would like to thank all the speakers for your excellent interventions and also for giving enough time for collecting all the questions from the audience and even some of my questions. I also would like to thank you and the audience for participating in the discussion about a quite neglected and under-researched and presented area of European data protection law. So I hope we did enlighten a bit the CPDP on how does the LED work and how it's supervised and enforced. I wish you all a pleasant lunch break, and maybe I'll see you later in Gather Town. Bye.
Thank you.
Thank you. Bye.